Hello and welcome back. My name is Matthew Seelig. I'm a white man with glasses, blonde hair, wearing a gray suit with a blue tie. Welcome back from lunch. This is the Disability Frame, Opportunities, Costs, and Constraints in the Broad Struggle for Inclusion, the University of Pennsylvania Law Review's Volume 170 Symposium. As we had with every panel, I'm going to start things off with our access statement, just to let everyone know our guidelines to make sure everyone can participate fully. We strive to be as inclusive as possible. To that end, here is some information about how this panel will go. We have ASL interpreters, Donna and Joy, and also manual closed captioning as standard accommodations for each panel and speaker during the symposium. We will orally identify ourselves when we are speaking. When we are speaking for the first time, we will describe our visual appearance. In all instances, we will state our name before we speak. If a speaker shows a slide, they will describe and explain what is on the slide. We encourage participants to use plain language wherever possible and define acronyms or avoid using them altogether. We have a few channels by which to ask questions. Anybody may type a question in the Q&A tab. That's the Q&A tab and not the chat, which we want to reserve for access, technical or logistical communications. We will have a moderator read those questions unless the person asking the question prefers to ask orally. To ask your question orally, please indicate you would like to do so in the body of your question, or alternatively, you may simply raise your electronic hand. We will then allow you to unmute yourself to ask the question. Finally, we will have a phone line where anyone can call in to ask a question. That number is 215-898-7060. You may also use this number to make accommodations requests or report technology issues. You may also alert us to these issues via the chat. And again, want to emphasize that the chat is for access, tech, and logistics communications, and the Q&A is where you can ask substantive questions to our panelists. There is CLE credit for this panel, so I'd like to invite Vanessa up to read us our first CLE announcement for the panel.
If you are seeking CLE credit for today's event, please note that CLE passwords will be announced twice per hour. Write down these passwords and enter them on your digital evaluation form once the event is over. The evaluation form is mandatory to receive CLE credits. The link to the digital evaluation form was emailed to you in your event reminder email. If you did not receive the email, please find the link to the evaluation form in the chat. These passwords will tell us how long you attended. The first password is SAGE.
Thank you, Vanessa. All right, this panel provides practice-oriented perspectives on the disability frame. Participants include Rebecca Cokley, David Ferleger, and Mehgan Sidhu. Rebecca Serbin will participate and also moderate the conversation. Partway through the panel, she will invite questions from the audience. Biographical information about participants is available in our symposium program, which is on the Dropbox, and I'll give the link to that in a moment. I would now like to give the floor to Rebecca Serbin.
Good afternoon. My name is Rebecca Serbin, and I'm a disability rights attorney, and I'm honored to be moderating the panel and taking part in this fabulous event. My pronouns are she, her, hers, and I am a white woman with medium-length brown hair, wearing brass earrings and a black sweater, and not visible on screen. I am an amputee and get around the world using a silver prosthetic leg. I would like to thank Professors Harris and Tani for your role in organizing this event, Matthew Seelig and the rest of the Law Review students involved in this event, and all of the Penn Law staff who made this possible. And I'd also like to thank Dalsa for your work and for existing at Penn Law. I am a Penn Law alum and was still sort of working through my own disability identity while a law student. And I really appreciate that you all have created this space at Penn Law. So as Matthew said, this panel brings together practitioners across disciplines. Among our panelists, we have many decades of experience with disability rights litigation, including both in the nonprofit and government setting, as well as experience with policy advocacy, philanthropy, and other areas. And their full and very impressive bios are available in the program materials, so I will not repeat them. But on behalf of the panel, I did want to thank the organizers for including the perspective of practitioners, in addition to the many insightful perspectives of the scholars in this event. And I will begin by turning to each of the panelists for them to each give some remarks on the symposium theme and on some of the previous panels. And then we'll turn to some questions that I've prepared for the panelists, and then we'll be sure to reserve lots of time for questions from the audience. And if you ask a question and want to direct it toward a particular panelist, please just note that when you submit your question. So to begin, I will turn to the more esteemed Rebecca on this panel, Rebecca Cokley.
The other Rebecca, it says that my camera is unable to load unless you let it. There we go.
Sorry about that all. We realized that we messed with a few settings, but hopefully we should be good now.
Thank you so much. My name is Rebecca Cokley. I am the only non-lawyer on the panel. I am a redheaded person with achondroplasia. I have about, let's see where we are now in the pandemic, chin length red hair, an abundance of freckles. I am wearing an animal print blouse and a black jacket. My pronouns are she, hers. And I have the pleasure of serving as the U.S. Disability Rights Program Officer for the Ford Foundation. As I said, I am not an attorney. I tried multiple times and my LSAT scores were epically bad. No matter how many attempts, what accommodations I accessed and needed, it just never happened. I want to actually take a moment to welcome everyone in the room that identifies as a part of the disability community or is still on your path to self-identifying. Wherever you are, I want to welcome you into this space. I am thrilled to see you. And our community is infinitely strengthened and made more awesome by your presence here today. So while the theme of the conference is the disability frame, and we've been approaching the conversation from a multitude of angles, my particular angle on this is thinking about how we strengthen the frame. I have been an activist. I grew up in the disability rights community. Both my parents were also little people. My dad ran a center for independent living. My mom ran a disabled student center at a community college. And so I joke that I rode into the movement and the community on the back of my godmother, Annie Coppola's wheelchair when I was probably 5 or 6 years old. Throughout my career, as I said, I've been an activist, I've been an advocate, I've been a bureaucrat, I've been a policy wonk, and now randomly I've ended up a philanthropist at this current phase. And so I've been privy to the practice side from a multitude of angles. Was joking with some friends the other day about the number of times people in the general public, parents of children with disabilities, the well-meaning, unknowing community will tell you if your rights are violated to just pick up the phone and call the ADA, and how we all sort of give each other the eye and the nod where it's like that's just not how things work. And we all joke about it. Some of us have actually even gone as far as to purchase an 800 number that we could just start handing out to people. That includes an informational snippet saying something to the effect of, you have dialed the ADA. Now what you actually need to do is the following in order to push for increased enforcement. And I think that's what it really comes down to in these conversations, is the importance of enforcement and regulation, two key things that were really reiterated over the past couple of days. Things are starting to change. I think when I look at 2020 election was a game changer for the disability community. We, in my work at the Center for American Progress at the time, really thought that we would be lucky if we got 2 or 3 presidential candidates to pick up on disability rights priorities and integrate them into their platform. We sort of figured the elimination of subminimum wage would be a key piece. increased funding for home and community-based services, marriage equality, and increased funding for the Individuals with Disabilities Education Act were sort of what we said as our like core 4 ideas. I remember walking through the airport and my cell phone ringing, and I answered it, and it was Vice President Harris's campaign saying that they really wanted to be the first to put out a platform, and they wanted it to specifically focus on economic justice and people with disabilities. And they quite literally copied and pasted a brief some colleagues of mine had written at the Center for American Progress as their platform. And that really kicked off what over the next several months was a much bigger, much more popular increase and pickup of disability rights and justice issues as key parts of the 2020 election. We saw 15 candidates issue platforms when it was all said and done, with as wide a variety as Vice President Harris's very concrete, very concise platform to a 35-page platform from Senator Sanders that I lovingly said included not just everything and the kitchen sink, but it included the backsplash, the tile, and the dish towels. Everything was in that platform. And I think it really happened for a number of reasons. The first, I think most important, is the power of the disability rights and justice movement. It is not an understatement to say that the Affordable Care Act still stands, because not just the activism tied to the 2017 protests, the power of watching the disability community do what it does and hold firm for the rights of all people to literally put their bodies on the line, be dragged from their wheelchairs, forced out of the Capitol, in a way that for those of us in the space have seen happen every now and then, but in the way that the rest of the country had never seen to that degree. But even more importantly, I would not say even more importantly, I will invariably get trolled for that in any second on Twitter. But equally importantly, the case law, the advocacy, the policy work that was being done by disability rights organizations, by our allies inside and outside government at that point in time. The result of that actually ties directly to this conference itself, was seeing leadership in both the House and the Senate also start to self-identify as people with disabilities. One of the most notable, my dear friend and big sister in this work, Congresswoman Ayanna Pressley, who I know you were all thrilled and excited to hear from yesterday, as was I. In addition to her, Representative Katie Porter, Senator Tina Smith, and a number of others, including obviously Senator Tammy Duckworth, all identify as parts of the community and see their commitment to this work as a true calling, not as a photo opportunity. They think about this work as a lens. If they're working on an education bill around student financial aid, what are the implications for students with disabilities? If they're working on a small business piece, why is it that people with disabilities and disability-owned businesses are not qualified for specialized loans and financial incentives, along with other marginalized communities? And it really does matter. That is sort of what the community has been fighting for forever. And I think also, as Professor Dwyer Reynolds said on the last panel, there is a real importance of seeing lived experience as expertise. And that's something I think a lot about in my work at the Ford Foundation, how Ford leads in this space and has been successful in pushing an agenda to use philanthropy to bolster and grow the disability rights and justice movements in creative and interesting ways. In 2016, our CEO, Darren Walker, issued a social justice platform for the foundation, where he dedicated the funding across Ford to the cause of social justice. And it was one of those loving moments that we start to refer to as ABD, but instead of saying all but dissertation, we know it's all but disability. Every community was at the table, every community was counted except for us. And I'm not gonna lie, and I lovingly say this to him on a regular basis, we trolled the hell out of him. We pushed back loudly passionately on social media. And to his credit, he invited us all in to have conversations. He took a number of years to unpack the bias that philanthropy has had around disability. Philanthropy has never invested in disability. In its history, the Ford Foundation had only ever really made one previous disability rights centered grant for $10,000 in the 80s. And it included a note that said, stop asking us for money, go ask government instead. And that was something that really threw our CEO off. And so he doubled down and committed to doing more in this space and to really leading in the space. So it included bringing on Judy Heumann and Catherine Hyde Townsend to lead this work from a consultant's perspective at the foundation, thinking about what the operations need to look like. What did the grant making need to look like across Ford's other lines of work? They created a president's council to bring together 17 other foundations committed to both hiring people with disabilities as part of their diversity strategies, committed to grant making around people with disabilities, both to disability-led and disability-centered organizations, as well as to mainstream organizations that wanted to be more inclusive, and also, then created the pot of funding that I now manage, U.S. Disability Rights Portfolio. And we brought in the community to talk to us. Our first year, we convened a series of community consultations, bringing in experts, disabled scholars, disability activists, disabled activists that had been mad at the community and went and did activism outside of the disability space, and asked them what they thought we should fund. And the number one answer was, we need a field. We need to build a field across the board. In a community that lives under a state of legalized poverty, having no field means we can't advance any other policy agendas we want, because we simply don't have the advocates informed and educated and positioned to be able to do the work. And so within the first year, we've started doing just that. The focus of building the field has led to the rebirth of an organization called ADA Watch to help monitor attacks on the ADA on the state and local level. We funded the ACLU Disability Policy Project. We're funding the Association of Rural Independent Living to continue growing their Academy of Young Disabled Activists, because we know that over 1/3 of people with disabilities in the country live in the rural community. Furthermore, our focus is really on economic justice, because as long as our community lives under a state of legalized poverty, things aren't going to change. So we funded the Century Foundation to build out the Disability and Economic Justice Roundtable. We're funding disabled researchers at UIC to actually break down equal pay data on people with disabilities, because women's organizations have actually fought to keep us out of equal pay day for years. We're funding narrative change through partnerships with groups like Rewire to continue to keep the focus on reproductive rights of people with disabilities, and the Inevitable Foundation, which is actually hiring, recruiting, and placing screenwriters with disabilities. And the last piece of it is really continuing to shift philanthropy. So we are excited to be partnering with the New York Women's Foundation on a number of projects, as well as to be launching what's going to be known as the Disability Philanthropy Forum, which will be a trade association of people with disabilities working in the philanthropic space. This also means for us thinking about how we fund the next generation of lawyers with disabilities and finding really creative ways to do that. And as I said, this is not just our stream of grant making for Ford, it's about how do we mainstream disability across all of our work. So when I was hearing the conversation earlier about environmental justice and how do we ensure that Black and Brown disabled activists are at the table in those conversations, that's something I think a lot about in my grant making. And how do I work with my partners on our natural resources and climate change team to make sure that they're both funding disability work, but they're also working to ensure that people with disabilities are included in their regular everyday grant making as well. And with that, I'm going to pass this back to Rebecca for my fellow panelists to introduce themselves.
Great, so I will now turn things over to David Ferleger. Oh, David, I think you're muted.
I'm David Ferleger. Hello, everybody. I'm a white man with a beard, black sport jacket, gray shirt, he and him. And it's both a pleasure to be with Rebecca, and Mehgan, and also to follow Rebecca, who illustrates the first of the several points I want to make, and so we can have sort of my views on the table, which is that the disability frame, and we've shown it by the content of this symposium, is really the human frame or the collective frame or a universal frame. Rebecca's description of her work and the Ford Foundation's current work demonstrates that we are really talking about something larger than the disability frame. And that is perhaps because the dominant social institutions that exist in the West, in the United States in particular, divide and oppress people and don't meet people's basic human needs. Rebecca's phrase about legalized poverty really resonated with me. And people with disabilities are especially harmed, particularly harmed, by the failures in every domain we've been discussing here for a couple of days and more. If you think about disasters, when a hurricane happens, a flood, people with disabilities are hurt the most and maybe first. Think about policing. George Floyd and the 9 minutes during which he was killed in prone restraint reminds me of the litigation in the disabilities field of children and adults being held and dying in prone restraint. Prisons, the discussion earlier today of prisons, same thing. Immigration, transportation, people with disabilities are particularly harmed by these deficiencies in our society. So to me, that teaches that the remedial actions, the preventive remedial actions that are most effective are those which are most universally applicable and most responsive to the needs of society as a whole. We know the examples in the police work, curb cuts, something I've been involved in along with Rebecca Serbin on this panel. Curb cuts are required under the ADA, but probably most people who use the benefits of curb cuts are people who are not in the so-called disabled universe. So what do? I think we, as litigants, as people in the disability movement, other movements, what we need to do, number one, is recognize the inadequacy with respect to the last 2 days of the narrow disability frame. And by the way, a little footnote, we need also to bring back the Constitution. I have to my left here, I looked at it before I prepared these remarks, a book called Disability Law, Cases and Materials, second edition. 680 plus pages. There are 11 pages on the Constitution. And I've written about ways in which we can begin to use again equal protection on behalf of people with disabilities in an article published recently. So we need to recognize that litigation itself, and I love litigation, I've been doing it for decades, litigation itself cannot be the major or even primary tool for social reform. And that's one reason why I particularly enjoyed, Rebecca, your talk today and our conversation the other day. We need to think of social reform as coming and growing from social movements, from transformations of consciousness. And we need to think of lawyers as serving those social movements. And we need to begin to figure out more and more how lawyers can serve those social movements. And the development of the organized, Rebecca Serbin mentioned it, the organized organizations and collectives of both lawyers and law students with disabilities is a way to begin to do that. So I want to close by mentioning, because it's a great lesson for all of us, someone who taught at Penn, at the law school. I've taught at the law school. He was a teacher of mine. Last Friday there was a symposium named after Edward Sparrow. Ed Sparrow was the first poverty lawyer in the United States. He helped and create really the underpinnings of welfare law, went on to create what didn't exist before him, health law. And when he died at a very young age, he was working on what he called the right to live, looking at how we can expand our lens to a larger picture in which lawyers have a role and the law has a role in supporting the basic human needs of all of us. So I appreciate everybody here. I am thrilled that Karen and Jasmine put this together, and I'm thrilled that we learn from all of us, this amazing collection of academics and practitioners and other folks. We learn from all of us a lesson of how much there needs to be done. Finally, I want to tell people, some people may know it, that in the Code of Jewish Law, the Talmud, it teaches it's not for us to finish the work, but we are obligated to at least begin the work. So we won't be done in our lifetimes, any of our lifetimes, but this is an amazing start for what has to be done. Thank you very much.
Thank you, David. And I will now turn things over to Mehgan.
Thank you, Rebecca. Good afternoon, everyone. My name is Mehgan Sidhu, and my pronouns are she, her. I'm a South Asian woman with medium length black hair, and I'm wearing a blue dress with a black sweater, blazer. It's a little chilly in here, so something to kind of keep me warm, and a silver necklace. And I also want to really express my appreciation to the Penn Law Review, to the Penn Law School, Dean Ruger, Dulce, Matt, Letitia, and to Jasmine Harris and Karen Tani, who worked so hard to put together this extraordinary event and really bring together practitioners as well as academics and other folks who are really impacted or just learning about the important issues involved in thinking through disability frames and how they fit and influence the law. So I think I'll just talk a little bit about sort of my own personal experience with disability frames and kind of where I've come from, and then how I've seen disability frames influence legal practice on the ground, and some thoughts about risks and harms, and maybe what we might think of given where we are now, and how to move forward. So I came to disability rights law practice in about 2006, working for a law firm, Brown Goldstein Levy, that does a lot of disability rights litigation, and worked. When I came there, I really had no. I had absorbed all of the sort of dominant messages about disability as being this sort of medicalized condition, maybe having more of a charity model. I hadn't really thought about disability in a rights way. But as I engaged more with the community, with disability rights activists, with disability rights attorneys, with clients, I really transformed my view, and saw the I think what was striking to me was that I'd always been someone who had, looked out for social justice and civil rights, but just didn't see how extensive the inequities are for people with disabilities. And in the process of working there at the law firm, and then in the federal government for a while, and then in the nonprofit sector, really learned a lot from mentors in the field who've been doing this work for so long, as well as younger folks coming into the field who were bringing in new and fresh perspectives. And that also caused me to really kind of rethink over the years the frames I was applying to disability, and to really be thinking more from an intersectional lens, as well as what I really appreciated Professor Endy's presentation earlier, thinking of my own identity and sort of different as a person with mental health disabilities who didn't also realize that I had those until or didn't think of them as disabilities until later, and also struggled with kind of how do I address this identity in the context of the work that I'm engaged in. So, all that said, I think there are a number of ways that I've seen multiple disability frames play out in practice that I think have a lot of impacts for us to really think about. How do we address those, maybe not just conceptually, but also in really engaged practice, and how do we sort of think about ways that we can apply frames that are thoughtful and intentional, and that are going to be helpful as opposed to harmful. So I guess one of the things I want to sort of stress about how practice, at least my experience in practice in disability rights litigation, has been really these sort of competing pressures, maybe, or like competing sort of different facets of how disability discrimination impacts people's lives, how to respond to them, and how these sort of external ideas about disability frame the responses legally and for clients. So I guess what I mean by that, I can give an example of, I think a lot of practice, as much as I was working mostly with people who were engaged in high impact and systemic litigation, but there's always this sense of urgency that that comes up, and I think that sometimes isn't as noticed in sort of outside of the disability law practice of dealing with clients who, for example, during COVID, I was working at Disability Rights Maryland, and we had most of the clients I worked with, I was working as an advocate at that time, and most of the clients were institutionalized in state hospitals or residential treatment centers, and then we had other clients in other sections of the organization who were in group homes and prison facilities and all these congregate care settings, who suddenly were really sort of left in this really dangerous situation, because many of them were high risk because of the disabilities that they already had, plus being in these congregate care facilities, and were really being sort of just ignored. A lot of attention was going to nursing home facilities, but not much really at all to all of these other people. And so that was kind of like jumping in to try to figure out what do we do? Like, this is a really urgent situation where people's lives are at stake. And similarly, folks in the disability rights and justice communities really just jumping up to address the medical rationing that began, and people were being denied ventilators simply because of assumptions that their disabilities rendered them with a lesser quality of life, and relying on state laws that permit that assessment to be made. And so I think a lot of practice is really has been responding to these really urgent situations. And just another example of dealing at times with parents or a mother who calls from a hospital because her baby has been removed by social services simply on the presumption of her disability. And now we have to go through all these legal hurdles and to try to get the baby back. And those are really kind of coming from all these different frames we've talked about, this kind of dependency model of disability, a medical treatment model of disability, looking at the costs and benefits of accommodations. And so all of that kind of playing into the lives of these clients and the really hard situations that they're facing in the moment. So being able to sort of address that urgency, I think requires a certain kind of approach to looking at how we apply the disability frame. And at the same time, I think a lot of what sometimes goes unnoticed in disability rights and justice law practice is how much energy and effort advocates spend and have for many, many years on really trying to just preserve the rights that we have under the ADA that are under threat. And I think a lot of that work goes behind the scenes. You're not going to see like some big case that comes out and is a landmark, because it's really just preventing the harms that that are about to happen or are sort of imminent. And some examples of that are recent attempts to where bringing disparate impact claims have been sort of under attack in cases involving disability rights law, which is really, a kind of severe, that has really big ramifications. And so that takes a lot of effort to really respond to and to be able to defend why that perspective is not right, and what dire impacts that could have. And then in another example, and this sort of goes back to I think the panel yesterday on costs and the sort of perspective of people with disabilities, being greedy or dependent or sort of suspect or vulnerable to other attorneys who are just out there to get a quick buck, and that has created a lot of I think there are a lot of well-intentioned lawyers who are maybe not as familiar with disability law as many who've been sort of practicing in the area, or who really are engaged in disability advocacy and have disabilities themselves, really have that understanding. And so as a result, I think there have been a lot of lawsuits, and I think this has been discussed, of kind of what some people call drive-by litigation, where hundreds of suits are filed against entities for architectural barriers or inaccessible websites, and then the message that gets out to the public is that these are these frivolous cases, and we need to respond by putting up more barriers for people to litigate disability rights cases by giving us more notice, even though the ADA has been in place for 30 years, and that's plenty of notice. So why aren't you accessible? So I think a lot of attention is also focused on those threats, and this poses a lot of challenges, I think, because we're sort of in a time too where there are long overdue conversations about systemic discrimination and race, about how that interplays with disability, and how our different movements maybe have or haven't acknowledged how the intersectional aspects of discrimination, and where do we sort of go with that. And I really have learned so much from disability justice advocates who have been really raising a lot of these issues and working very hard to bring them bring the attention they need to the front. And so I think that also creates a tension in a way of how do we, as people who are working sort of on the ground, address the present urgencies and preserve the sort of limited laws that we have, while also really thinking longer term about who are we, what we're disability rights, and nothing about us without us, but who are us. And I think like that reframing of who we are, that's ongoing, and that's a longer, probably like a longer process to think through. So I think sometimes I notice this tension between kind of wanting to be protective in bringing a disability frame that's really kind of focused and centered on kind of where we are and what we have, and preserving when that's really under threat, and then really recognizing increasingly the need to really like change what our frame is, and how do we really adapt that and bring that into where the law is right now and where people are right now who are experiencing really significant hardships in their daily lives. So from that, I've been thinking a lot about these ideas, and I've loved this symposium, in part because it's really given me a chance to hear so many other thoughts, and I've been just thinking through some of these questions, and so I will share just some thoughts in response to some of the previous panels, but certainly look forward to feedback, because they're just sort of some of my thoughts at the moment. But I think I'm going to turn to Jamelia Morgan earlier put it so well, how shaping the complaints and pleadings and being really thoughtful about what we are saying and what we're not saying and what frame is involved is really important. And I think that's something that sort of spans whether you're thinking kind of more in the longer term of where are we going, or in the immediate term of how do I help this client, where and also gets to what Professor Endy was saying about just it's individuals that really kind of bring the change in a way and through a collective action. But one way I tend to think about that is what you have, kind of what the law says, you have the client's experience, you have a particular defendant and the people who are representing that defendant, and you have a judge and maybe other, and I think kind of being really reflective about what are the frames that each of those entities and individuals are bringing to this claim of discrimination, and how can I use kind of the space in between to craft a narrative and shape a case that really reflects my client's experience as a human and attaches the identities that they have and that connect to others as well. And so being really thoughtful and careful about the language and the story, and not sort of falling into the language that that is so often used that just reinforces stereotypes, I think is really important from the outset in sort of shaping how we think, what our frame is and what our frames are going forward. And then a second part of that, I think, is really listening and collaborating, and that maybe sounds sort of like we should all just listen to each other, but I actually really think having conversations like this among practitioners and academics, people who have lived experience in particular, and really centering their expertise, as well as people who have been engaged in other civil rights law and activism really can help generate a lot of learning from each other as we kind of rethink some of these bigger issues about what are the frames that will be harmful or will be helpful. Sorry, I don't know if that's my phone. But in any event, so I think having more conversations is another way to do that. And a third point that I think we can pay more attention to is data, and that's something that in the costs analysis presentation yesterday was raised, and particularly Professor Karen Gustafson's suggestion of challenging some of these assumptions that disability accommodations are costly with alternative data. And I think, as Amy Robertson had maybe chimed in, that's something that it would be great. Like, as an attorney practicing, I feel like I didn't have a lot of evidence, even though I know that that there are benefits and that there are other costs, broader costs to society in not accommodating or providing accessibility or universal access. It's very hard to find data to support that. And even if I don't personally think a cost benefit analysis frame is like, places the values in the way I think that they should be, that is where people are. And so how do we sort of build data to really help to demonstrate some, really just to even know kind of what does, how might that look, or what are the other considerations that aren't being included. And I think too, with a lot of there's a lot of big data and kind of attention to data analysis and data analysts, and maybe opportunities to kind of think about how to go about creating that data. And so then the final thing I just want to mention is I think hopefully there are lots of, or will be lots of examples of ways to kind of pull all of this together to help create the disability frame as we go forward in a way that's really thoughtful and that's really helpful. And that I was thinking of this example from a presentation I had heard a couple of years ago from two attorneys who had brought a class action complaint against the Sacramento City Unified District, and really tried to make this an intersectional complaint. So what had happened was there was a group of parents who were very upset about their children who were both Black and had disabilities, and were being excluded from the classroom, as well as being suspended at higher rates. And they a couple of reports had come out, one showing the impact on disability from an audit of the school district, and another showing how the rates of disproportionate discipline for Black students was so substantially higher than elsewhere in the state. And so Disability Rights California, which is the protection and advocacy organization for the state of California that does disability rights work there, worked with a couple of other organizations that were that had a lot of experience with dealing with race and poverty and race equity, and came together and really looked at a lot of the data of discipline and disability and race, and found through that data, we're able to show that half of the students with disabilities in the district were segregated either to separate schools or in separate classrooms. That if you were Black and disabled, you were twice as likely to be suspended than a white non-disabled student. And if you were Black and disabled, and you had a subjective, like, sort of disciplinary infraction, like willful defiance, you were 50 times more likely to be suspended than a white student without a disability. So they came together and created this complaint, drafted a complaint that really centered on the segregation aspect that was common to both disability and the race discrimination claims, and filed a class action suit under the ADA, the Rehabilitation Act, the Equal Protection Clause, Title VI, and also state law. And that that's a complaint that was filed and I think has been stayed pending negotiations. So it's not something that has gone, far in the courts, but I think that's one example of maybe how we can think about moving forward. So, thank you.
Hi, everyone. This is Matthew. I'm going to jump in because it's time for our second CLE code. Vanessa, could you give us our CLE announcement?
The second CLE password of this session is MINT, spelled MINT.
Thank you. So we will now proceed to the Q&A part of this panel. And so thank you for those who've submitted questions, and please keep the questions coming. So to start with, for whoever feels like answering it, as a practitioner, this is a question from the audience. As a practitioner, often my biggest problem is educating my judge without offending their ego. This problem will never stop unless and until webinars like this are required viewing by judges. Meanwhile, what strategies have you found that can help practitioners? For example, has anyone tried using a law professor with a mental health disability as an expert witness to provide the kind of judge education necessary to achieve justice? And if not, why not? David, you're muted.
I'll chime in for just a minute. The best education is people with disabilities, whether it's a child in an institution for whatever the child was committed for, or a person who can walk for whatever reason. The best education is for judges to get to know people who have disabilities. Much better than a law professor coming in.
Fair enough. And I'll also say from my own practice that we found that we often have to do a lot more really basic education than we would expect. We sort of assume that judges, that we really can't come in and assume that judges have thought at all about these issues, have thought at all about what it is to be a person with a disability, or some of the kinds of sort of what that looks like day to day. And so that we have to often really start with some basics and not assume a lot of knowledge. But I hear you on some of the challenges of doing that without offending judicial egos. So throughout the conference, we have heard some discussion about sort of issues and tensions involved with the decision to self-identify as a member of the disability community. And Rebecca spoke earlier about the impact it's had to have members of Congress and other folks in positions of power self-identify. But we also heard earlier that many people in our disability community who would qualify under the ADA definition do not choose to self-identify. And so how do we think about the role of privacy in these conversations? People with disabilities, like other marginalized people, are sometimes subjected to state surveillance and often lack privacy. And we understand the reality that different disability identities carry different risks of stigma and discrimination. And so what is the role of people with less apparent disabilities in the disability justice movement? And how do we fight for different visions of disability in society without requiring people with disabilities to claim disability or come out if that's not something that they wish to do?
This is Rebecca. I'd love to jump in on that. It's something I think about a lot. As I said, I have dwarfism. So, when I walk in a room, I understand that there is both a level of privilege and stigma that I face. I have a privilege of no one's going to ask me why I need a step stool. They're going to look really awkward if they do, or why I need something lowered down. But as a person that also lives with blackout migraines, I have been in roles where, when discussing my need to have a dark, cold room to lie down in, have found myself question. I do go back and forth, and I know a number of folks go back and forth on how we disclose. I mean, one of the first documents I ever worked on in my itty bitty baby nonprofit days, now I can't believe it's 20 years old now, was the 411 on disability disclosure for young people with disabilities at the Institute for Educational Leadership when I first moved to DC. And we developed that because there was no guidance for young people on what we refer to it as how to disclose and not sound like a geek, was the terminology we used at the time. Because we were all in our early careers, in our early 20s working on it, and I continue to see the opportunities and the challenges. I also think that we live in a society where we have put systems in place that in order to get any level of access or service provision, we almost have to put on the Sarah McLachlan in the arms of the angel song behind us as we tell our story. We're put in a position where we have to tell the worst case scenario about our existence as disabled people to get any attention for the accommodations or the services that we need. And I think that has created this sort of all or nothing case that you either disclose, and if you disclose, you go full tilt, you rock the disability pride t-shirt, you tell the worst case scenario to get, a basic level of access to services or your rights, or you don't disclose and you sort of suck it up and work your way through it. And we know that also doesn't work. And I think, honestly, the thing that's scaring me the most in this conversation nowadays, especially in light of COVID, is the fear that we're going to see so many more disabled students go back into the closet or no longer invite us into their disclosure truth because of schools pulling back accommodations now and students being gaslit on college campuses. And so that to me is a place where, as elders and yelders or young elders in the movement, we have a responsibility of showing up and providing support, whatever that looks like, actually physically showing up emotionally, showing up with our dollars to help support disabled law students associations. So this horrible trend doesn't continue.
Absolutely. In the last panel, Professor Morgan described some of the ways that both stigmatizing disability frames and productive disability frames have been used specifically in her panel in prison rights litigation, and discussed how practitioners and others can center disability without inadvertently stigmatizing disability. And so certainly echoing the importance of this issue. And one related issue that's come up sometimes in my practice is sort of the related issue that my organization often uses the media to discuss our work sort of as a public education tool to get people to understand that these issues remain prevalent, and also sometimes more specifically as part of a class notice process. And sometimes in the process of using the media, we find that the media coverage uses stigmatizing disability frames and ableist language. So what are your thoughts on how to strike a balance between using the media as a tool and avoiding those unintended consequences as practitioners? If no thoughts, we can move on. But if any come up later, and we had a sort of related question in the chat about sort of how to, that given that law is a top-down vehicle for social change, and that we ultimately need to work toward a future where disability rights permeates culture so that it becomes morally reprehensible to discriminate on the basis of disability, do practitioners have a responsibility to keep an eye on how culture treats disability rights and responding appropriately to good and bad depictions of work by journalists, fiction writers, filmmakers? And if so, how best can we do that?
I will jump in on that because as a little person, I have a lot to say about this year. I think that there is a way, we do have a way of weighing in. I think we need to continue to weigh in on both negative portrayals and positive portrayals. I think that we collectively, and this is what I heard about the disability community for years on the Hill, we're very quick to say what we don't like. We're less quick to say what we do like. This last month, when Disney came out talking about their brand new Snow White movie and their continued portrayal of 7 little people with no agency and no personality, kind of like 7 ex-boyfriends of mine, I guess, maybe. You know, there was a real backlash in the community, and it was really controversial. There was, you know, people like Peter Dinklage saying, how can you award yourself for being quote unquote woke with a Latina Snow White if you're just going to have 7 disabled people playing the same role that they've always played. There were reality stars and reality producers who directly profit off of the subjugation of their own community of other little people, who said you're taking good work away from people who need jobs at a time where disability visibility continues to not be great. I continue to say, why are we satisfied with the same old boring things? Why are we satisfied with the episode of the week where some non-disabled person learns to be inspired by a disabled person? We have an amazing history. You know, my thing was, why are we talking about those 7 dwarfs? Why aren't we doing a film about the Ovitz family? Why aren't we supporting disabled filmmakers, disabled screenwriters, which is what we're doing at the Ford Foundation through the Inevitable Foundation? And our work with groups like Just Films, who's our colleagues that actually do the documentary and the film production at the Ford Foundation, to lift up alternate stories. And I think as practitioners, you know, I know lawyers who continue to, I mean, we live in a country where the death penalty in Texas still uses the Steinbeck, are you more or less intellectually disabled, as Lenny of Mice and Men, to decide whether or not a disabled person can get the death penalty. Like, we have to fight this stuff. Our people are literally dying because of bad media depictions. And if there's anything that's, you know, I mean, it gets me upset. I'm just so enraged by it.
David or Mehgan, do you want to weigh in on this at all? We can move on. Okay. So as Mehgan referenced earlier, yesterday we heard a wide-ranging discussion about the cost narrative, sort of the idea of disability access as burdensome, expensive, or coming at the expense of non-disabled taxpayers. And so how have you seen this cost narrative kind of come up in your work? And other than sort of some of the great ideas that Mehgan shared about the role that data could play in this, how do we fight back against this narrative and ensure that conversations about the cost of access also include the cost of a lack of access and the benefits of access?
That's a great question. And a couple of thoughts I have. I think this comes up a lot in sometimes in, I think of education litigation, trying to sort of change accessibility practices, or in other kinds of looking at what are the costs of bringing in access and shifting kind of how the system tends to work, both as oppositions in just trying to negotiate or advocate, as well as in litigation through defenses. And I think that becomes a bit challenging because of there's such a kind of a sense out there that this is costly, and so how do we sort of overcome that that more dominant kind of way of thinking about disability as expensive? And one way I think of is just really kind of for clients to be to hear the client's story of how they're really impacted. I think putting that human dimension on it and showing how like this kind of cost narrative is really conflicts with, it really has really bad impacts. And another way, not using data, is to look at, well, what are the mission and values of the organization or the defendant, or because most organizations don't say like our goal is just to like make lots of profits. There's some sort of greater mission or value often in what is trying to be offered, and so appealing to kind of that value side, I think, as well, and presenting that in the story can also be effective.
So I want to say something about that, because two things. Number one, obeying disability laws or principles is typically less expensive than what we do now. Uh, and it applies first, let's use the institution as an example. Institutions are far more expensive than community services for people. And facilities, homes for people who have been convicted of crimes is also less expensive in the community than large congregate prisons. And often cost is just used as an excuse. Take businesses, for example, in public accommodations. A business that figures out ways to make its place accessible to people with disabilities expands their potential customers, and the cost of compliance is not that great. I was involved in the litigation against Chipotle, the fast food place that had counters that are too high for somebody to see over and get the so-called Chipotle experience. So when they were ordered to lower their counters, they then had thousands more potential customers who could come in and enjoy the food. I've never been there, but that's what I heard. And there is an effort in some parts of the country by the business community. I won't go into what the litigation, the Winn-Dixie case that I'm involved in, where the National Chamber of Commerce is arguing that websites are not places of public accommodation because it would be too expensive to make a website accessible. For companies that are big enough to have the kind of website some of these do, the incremental cost of being accessible, which is pretty simple for any web developer, costs almost nothing. So some of the stigma and the discrimination and the stereotypes and the negative attitude toward people with disabilities finds its way into making costs an excuse. And the other piece, I mentioned the US Constitution. If we figure out ways that some things can be protected under the Constitution, then cost probably disappears as a acceptable excuse.
I would say I found in my work that cost comes up all the time, but it's so much, like David is saying, it's so often just so clearly an excuse. It sort of comes up as a vibe, to borrow from our Gen Z colleagues. But when it actually comes down to sort of proving an undue burden defense, the defendant has nothing to show for it, but still sort of understands that because that narrative is compelling, they'll sort of imply that that's an issue going on, even though they have no facts.
By the way, Larry Berger asked a question about where he could find the law review article on the constitutional rights involved. I don't know if it's accessible to everybody. In the Q&A under answered, I have citations and a Dropbox location for 2 relevant articles.
Great, thank you, David. A question from the audience for Rebecca. Richard Kluger and Mark Tushnet's work on philanthropy's co-opting and redirecting of the civil rights movement seems to raise real questions about how and how much foundations should engage in legal reform work. I'd love to hear more about Rebecca and the other presenters about how foundations should grapple with the tension between supporting movements for justice without co-opting.
This is Rebecca. Thank you, Rebecca, for that question. And thank you, Colin. I think about this every day in the grant making that we do. It's impossible to work at a place like the Ford Foundation with a CEO, like Darren, who constantly talks to us about embracing risk and reflecting honesty in the work that we do. While the Ford Foundation has done completely amazing things, really powerful things, I joke that you can't turn on the television without seeing something that we funded or something that we've supported. There has also been horrible things done by philanthropy. The history of the eugenics movement in the West, and actually pretty much everywhere in the globe, is the legacy of these founders that were had less than progressive ideals when it came to how to use their funding. And it's something that we actually talk about quite regularly. We had a symposium last year focused on the history of philanthropy and eugenics and the impact on the disability community, where we brought in Lydia XZ Brown, we brought in Joe Stramundo and a couple of other thought leaders to talk about that and to really weigh in on how should the legacy of the wrongdoing of philanthropy help inform the work that we were trying to do now. We can't do the disability work the way that we want to by just sweeping that under the rug. And so what we've really worked to do is to actually center the conversation, to allow the grantees to center the conversation. And in the beginning of our grant making, we had 3 community strategy sessions with groups of disability leaders. We had over 150 one-on-one conversations with folks as we were actually building out our strategy to say, does this work with you? Like, what do you think the issues are? What are the challenges? How do we frame this in the right way? How do we focus on areas that are endemic in our community, but at the same time, broad enough that allow people to be flexible and thoughtful, and for the communities themselves to drive their approaches. You know, are we perfect?
Mind if I chime in very quickly? Could I just ask for our whole panel to just slow down a little bit the rate of speech? We're having a tough time for our interpreters and captionists to keep up, and want to make sure that we're getting everything down. Thank you.
Thank you. Thank you. You know, so I would say something that we have really worked to do is be in continued conversation with the community, is to, I ask my grantees regularly, who else should we be funding? Where are the gaps? What are the things that I'm not thinking about? Where are the emerging fields of discussion and rabble rousing? You know, I will say that I look to social media to help inform what we're looking at funding. I look at what's trending and what conversations are being discussed. I will say I hopped into a Twitter Spaces about 2 weeks ago that was hosted by my colleague and good friend Matthew Cortland to talk about the impact of COVID on our college campuses for college students with disabilities, and you know, a large number of which were also law students with disabilities. And it kept me up all night. It kept me up all night from a multitude of nights. And I ended up reaching out to a handful of folks that were on that Twitter Spaces, and we hopped on a call. And I said, what can we be doing? How can we address this issue? You know, I think for years as an activist, I used to sit around and say, it would be really great if we had X, but we don't have the funding to do so. Or nobody's going to support us to build you know, an organization working at the nexus of food security and disability. And so I joked that when I got to the Ford Foundation, I had a notebook where the back page said quite literally, cool shit that the Ford Foundation needs to fund, based on conversations that I had with grassroots activists, with thought leaders, with Hill staffers over the years, and have worked through that list based on the feedback from the community. And so I think that's the most important thing. I think it's really easy in places like philanthropy and places like the upper echelons of academia to get stuck in your office. And, you know, we know that when you're stuck, when you're segregated, whether it's you're segregated by yourself or you're segregated by whatever institutional mechanism, you're not hearing the whole story. So working to get out to hear the truth of the community and to let the decisions that you make be driven by those that are closest to the pain, as Ayanna always says, that is my true north in the work that I'm doing at Ford.
And there, you know, as you mentioned, there's sometimes been a gap between the world of academia and the world of sort of practice and what's happening on the ground. And so we very much appreciate that this symposium is including the voices of practitioners along with the voices of scholars. And I wondered for this panel, if you had thoughts on sort of, are there things that you want legal scholars working in this area to know from your perspective as practitioners that you think sort of don't tend to come up or maybe tend to be ignored?
I would say, this is Rebecca, I would say if there's something cool you're working on, if there's something amazing that's keeping you up at night, and you don't find the support that you need to do that, reach out to me. I love nerding out on like I said, I'm not a lawyer. I wish I could be one when I grow tall, but that's not going to happen. Actually, I don't. I'm perfectly happy where I am. But to be in a position where we can help support that kind of work, we're really excited. The announcements aren't public yet, but there are a number of individuals whose work in academia we have supported in our first 2 years of grant making. I'll be even more excited once that word is out and I can actually talk about it. But that's something that philanthropy can be doing. And so if there are things that you care about that you're having a hard time moving, please reach out. I'm happy to be a thought partner. And I'm happy to think about if it's something that either we can support or one of our foundation partners can support.
That's a great question, and it's hard to answer because academics, so-called law professors, are so varied in what they teach, how they teach, and because law schools in recent decades more and more are supporting students in learning the practical side of being an attorney. I know from teaching at Penn and earlier at NYU Law School that students are hungry for stories. Students are hungry to know what happens in the courtroom and in representing people. And I think more and more law professors have that experience and teach in ways that bring in the outside world. I think of Martha Field teaches now at Harvard. Martha was the first female law professor at Penn Law School when I was a law student years ago. And she went right from law school to a clerkship for a Supreme Court justice to teaching. She taught civil procedure and had never filed a complaint or litigated a case or represented anybody. So that part of the world is different, and I think that we see from a lot of the discussion at the symposium the extent and depth of experience of so many of the academic folk in this world. So I'm really proud of that and proud that we're having this kind of quality faculty teaching these 2 days.
Absolutely. One topic that came up yesterday during Professor Harris's panel was the idea that some of the time when we are litigating cases, particularly involving internet-based businesses or websites, that we run into some of areas where the current version of the ADA can feel deficient. And a member of the audience raised the issue of whether we should be pushing to amend the ADA. And there were thoughts shared about some of the potential downsides of doing that, and also the potential to be filling some of these gaps through regulation and through moving regulations forward that made it very close during the Obama administration in this area, but didn't make it all the way through. And so wondered if folks on this panel sort of have thoughts on whether or not amending the statute should be part of the strategy, or sort of how you think about that. It seems that Rebecca Cokley may have a view.
We are not opening the ADA anytime soon. I will jump on in front of whatever moving train gets going before we open up the ADA. This Congress is not a nice Congress. This is not a pro-disability rights Congress. This is a Congress where my former representative every year actively introduces bills to repeal Title III of the law, and is looked at as a hero and a champion. And I have no idea what it is that she's thinking most days. We are not in a position where we can productively amend the ADA in all the ways that we need to. And I think that there's also a conundrum about, so if we were to open the law, are we in fact saying that the ADA is not as all encompassing as we think it is? And where do we stop? Because I mean, I could think about amending it for police violence. I could think about amending it to protect the civil rights of disabled parents. I could think about amending it for technology and the internet, so that celebrities with disabilities can access the Grubhub at 2 a.m. in Los Angeles. You know, but my real fear is knowing where Congress is at right now. We do not have votes that we would need to do it effectively. And so I do think that it's the time that we continue to push for increased regulation. I think it's the time that we lean on federal agencies and Hill offices to push for more guidance. But yeah, no, like I will totally go old school and, you know, put myself as a damsel in distress and tie myself to some railroad tracks before we go there.
This is Megan, just jumping in to say I completely agree with Rebecca. And I think Jasmine addressed this point yesterday as well. So yes, I don't think opening up the ADA is a good idea, but regulation and other advocacy from agencies is a better way to go.
God forbid we should try to amend the ADA now.
Fair enough. Consensus on this issue. We have, although I will say, as someone, you know, litigating these cases, there are days that it would be a lot easier if there were, you know, other things in the statutes, and if we didn't have certain opinions out there that had really limited the ADA in certain ways. But I certainly agree. A question from the audience about accommodations for litigants. In litigation, accommodation requires disclosure, which can create bias. Shouldn't there be an ex parte process where with the judge engaging in an interactive process, getting comment from the adversary and judge as to any rights negatively affected, and then ordering an accommodation? So for the litigators on the panel, sort of thoughts on how accommodations processes in courts tend to work.
Well, I'll say something. I think it's more than just courts. I think until we have a society where it's not a potential punishment or negative for people to disclose a disability or to request an accommodation, there are many environments in which it would be good to have some fair, neutral, in-between or confidential way to address that issue.
Absolutely. And perhaps for a closing question, sort of in describing the idea of the disability frame at the beginning of the symposium, Professors Harris and Tani talked about the idea of, you know, using disability law to address kind of seeing issues through a disability law lens, and that there being sort of pros and cons to this, with kind of the biggest recent example of a negative way of seeing this is for folks who didn't want to wear a mask or didn't want to get vaccinated, claiming that it was their ADA right to not do so, of course, with a caveat that there are people who, for disability related reasons, cannot wear a mask or get vaccinated, but that this narrative was certainly being pushed by folks to sort of take advantage of the disability frame in a way that was not furthering disability rights. And so we sort of have the tension between those kinds of situations with people walking around claiming to have an ADA card that means they don't have to wear a mask, with the idea that we tend to push in the community of the importance of seeing all issues as disability issues, because disabled people are affected by, you know, healthcare as a disability issue, and education as a disability issue, and the environment as a disability issue. So how do we sort of balance those two things, of kind of not letting disability be co-opted, but making sure that it kind of remains a part of all of these conversations?
So this is Megan, and I think one important part is to really be trying to center and look to people who are part of the disability community, who identify as having disabilities, who are experiencing harms, and aren't just sort of co-opting the laws that exist for their own, for other benefits, but really ensuring that their voices are really centered in helping to move the perspective forward.
Well, let's see. We have one more question from the audience we will fit in. ADA accommodations in the courtroom often don't work, and one strategy when denied is to immediately contact the presiding judge. And the audience member has been told by the ADA coordinator that there was no way to appeal a denial, and so they contacted the presiding judge. And so, because by and large, the sort of ADA coordinators having a lack of training and necessary to go through the judge. So have Mehgan or David, have you had sort of experiences where you ran into issues getting those accommodations in courts, and if there were sort of strategies that worked for you, if you have thoughts on that issue?
Well, of course, it depends on the court, on the judge. It may also depend on the clerk's office, especially in federal court, or the judge's federal court deputy clerk. I have not had that as an issue. And there are some federal judges, if we're talking about federal court, who have disabilities or who are very knowledgeable and helpful. And they may, depending on the situation, be able to help or advise. But this reminds me, Rebecca, I'm going to say something that I was going to talk to you about privately. Somebody else raised the question earlier about educating judges, and joint effort by the Ford Foundation and the Federal Judicial Center to bring some education to judges would be a terrific idea.
Love it.
I'd be happy to help with that.
Let's talk about that.
And I'll say, with accommodations, that we've generally found that courts are reasonably cooperative, but that one situation that has made that a lot more difficult is during COVID, when we've had judges who were not, perhaps because of their comfort level with technology, sort of decided that we were at a point in the pandemic when they wanted people in person, and who were not interested in accommodation requests related to that, even though the courts had been operating successfully remotely for many, many months at the time that these issues came up. But certainly that is an issue that is frustrating outside of the court context as well. We've now reached the end of our time, so we just wanted to thank the panelists so much for their insight and time today, and to thank again to the organizers of this event for including the voices of practitioners, and all of you in the audience for your insightful questions and for your willingness to be on Zoom on a Saturday, which is no small thing. And so it's, thank you very much.
Thank you so much, Rebecca. This is Matthew. And thank you so much to all of our panelists for a really great discussion. I'm going to turn it over to Vanessa, who will give us our final continuing legal education announcement for this panel.
If you're seeking CLE credit for today's event, please remember to fill out your digital evaluation form and include the CLE passwords announced throughout this event. The evaluation form is mandatory to receive CLE credits. Please find the link to the evaluation form in the chat. The last password is HERB, spelled H-E-R-B.
Thank you so much, Vanessa. Our last panel will be at 3 o'clock. So after a half-hour break, entitled The Future. We're very excited and we'll see you then. Thanks.